Hello everyone. Welcome back to our channel, U.S. Immigration. We hope you're doing great. In this video, we're going to talk about USCIS and Trump's roster, who is protected from deportation. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Immigration law in the United States can often feel overwhelming, especially with so much misinformation spreading in communities. Many people live in constant fear of deportation, not realizing that certain groups are legally protected and cannot be removed unless they commit crimes or violate the terms of their status. Let's carefully break down the categories of individuals who fall into this protected list and understand the nuances behind each group. 1. U.S. citizens, the safest group. The strongest protection from deportation belongs to U.S. citizens. This includes both citizens by birth and those who obtain citizenship through naturalization. Once an individual has taken the oath of allegiance and received a certificate of naturalization, they cannot be deported unless they engage in serious criminal activity, such as fraud in the naturalization process. 2. Legal permanent residents, green card holders. Green card holders are the second most secure category. As long as they follow the law and do not commit deportable offenses, they cannot be removed from the country. This protection also extends to conditional residents such as those who gained residency through merit provided they fulfill the requirements of their status. 3. Temporary protected status beneficiaries. Individuals from countries designated under TPS are safe from deportation, while their protection remains in effect. As long as they renew their status and avoid criminal violations, they remain shielded. 4. Asylees and refugees. Those who have been granted asylum or refugee status are another protected group. These individuals fled persecution in their home countries and were lawfully given protection. In the U.S., their status prevents deportation unless they break the law or pose a security threat. 5. DACA recipients. Although deferred action for childhood arrivals has faced numerous legal battles, recipients are currently protected from deportation. While the program's future depends on ongoing court rulings, beneficiaries remain safe under protection for now. 6. Humanitarian parole holders. People granted humanitarian parole, often due to urgent circumstances such as medical emergencies or fleeing violence, are safeguarded. While this protection is usually temporary, it shields them from deportation during its duration. 7. U visa and T visa holders. U visas are available for victims of serious crimes who assist law enforcement, while T visas protect victims of human trafficking. Both groups enjoy strong protection from deportation, recognizing their cooperation with justice and their vulnerable situations. 8. Court order protection. Some individuals cannot be deported because an immigration judge has issued a court order preventing removal. These protections are legally binding and shield them until further proceedings change their status. 9. Collaborators with security agencies. Individuals cooperating with U.S. security or law enforcement agencies, such as witnesses in investigations, fall under this category. Their assistance provides them with protection from deportation, while their collaboration remains essential. 10. Unaccompanied minors in court proceedings. Children who arrive unaccompanied and are in active immigration proceedings receive temporary protection. The government does not deport them until their case has been fully heard in immigration court. 11. Immediate relatives of U.S. citizens. This category is particularly important. Immigration law allows immediate relative spouses, parents, and unmarried children under 21 of U.S. citizens to adjust status, even if they have worked without authorization, overstayed their visa, or violated their status. The law, INA Section 245, provides forgiveness in these cases, as long as the person initially entered the country legally, with a visa and inspection. Why employment or overstay does not eliminate protection. Even if someone worked without authorization or overstayed their visa, they may still qualify for protection and adjustment of status if married to a U.S. citizen or if they are an immediate relative. The reasoning behind this is that these individuals entered the country legally, underwent security checks at a U.S. consulate, and were inspected at entry. Their prior screening grants them eligibility for forgiveness under immigration law. Who is not protected? It is equally important to note that those who enter the U.S. without inspection, for example, crossing the border unlawfully without a visa, are not covered by these protections. Without legal entry, they are more vulnerable to deportation proceedings. Waiting for U.S. citizenship? Immigration authorities to now scrutinize applicants' good moral character. In an effort to tighten access to U.S. immigration benefits, the U.S. Citizenship and Immigration Services has announced a major policy shift, restoring a stricter and more comprehensive assessment of the good moral character requirement for foreign nationals seeking American citizenship. Among other eligibility factors, aliens applying for naturalization must demonstrate that he or she has been and continues to be an individual of good moral character. Evaluating GMC involves more than a cursory mechanical review focused on the absence of wrongdoing. It entails a holistic assessment of an alien's behavior, adherence to societal norms, and positive contributions that affirmatively demonstrate good moral character. The policy memorandum, issued on August 15th, read, "The policy highlights that while certain offenses such as murder, aggravated felonies, torture, or genocide remain permanent and unconditional bars to naturalization, officials must now also assess evidence of rehabilitation and reformation in other cases." In fiscal 2024, year ended September 30th, 8.18 lakh foreign nationals acquired U.S. citizenship. Mexicans led with as many as 1.07 lakh becoming American citizens, 13% of the total. This was followed by Indians, with a little over 49,000, or 6% of the total, acquiring U.S. citizenship. Positive attributes and contributions such as sustained community involvement and contributions in the U.S., family caregiving, responsibility, and ties in the U.S. Educational attainments, stable and lawful employment history and achievements, length of lawful residence in the U.S., compliance with tax obligations and financial responsibility in the U.S. will carry greater weight. What are key features of the policy? As per the policy published by the USCIS, the officers must account for positive attributes and not simply the absence of misconduct. In evaluating whether or not an alien has met the requirement of establishing GMC, the officer must take a holistic approach in evaluating whether or not an alien seeking naturalization has affirmatively established that he or she has met their burden of establishing that they are worthy of assuming the rights and responsibilities of United States citizenship, according to the document. USCIS will place greater emphasis on the applicant's positive attributes and contributions in GMC determinations. These positive factors include, but are not limited to, sustained community involvement and contributions in the United States, family caregiving, responsibility, and ties in the United States, educational attainment, stable and lawful employment history and achievements, length of lawful residence in the United States, compliance with tax obligations and financial responsibility in the United States, any hope for applicants with past wrongdoing. However, there is a glimmer of hope for applicants with a record of past wrongdoing. Under the new guidelines, USCIS officials will consider concrete evidence of rehabilitation such as repayment of taxes, adherence to court-ordered conditions, or testimonial from community members. Such proof may still support a determination of good moral character, despite a negative history, as long as no permanent bar is in place. That is all for today. In this video, what are your thoughts on this? Please let us know in the comment section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.